So imagine you're standing in a 17th century town square. A crowd is gathered, but they aren't there for a market.
Right, they're there to watch someone be publicly tortured.
Exactly.
Yeah.
Back then, justice was, well, it was something the sovereign just did to your physical body.
Yeah.
You know, to show who was in charge. There was absolutely no rights talk at all.
There's just the king's will.
Yeah, just the king's will. But today, we've moved from breaking bones to trying to fix minds. So today we're diving into a stack of sources for this exploration into the source material. We're looking at the history of penal law, moving from the 18th century Enlightenment right up to the modern Nelson Mandela Rules.
And we're going over a concise history of legal frameworks, right? Like the UDHR, the ICCPR, and specific rules for vulnerable groups like the Beijing and Bangkok rules.
Right. Because it's a total shift in how we actually view the human being.
Oh, for the longest time, the body was the target. If you stole a loaf of bread, you lost a hand.
Yeah, and then the Enlightenment changed everything.
Exactly. I mean, think about 1764. A guy named Cesar Beccaria and also Jeremy Bentham, they published ideas that basically said, hey, if we want to stop crime, we don't need to be monsters.
We just need to be predictable.
Right. We just need to be predictable.
It's that rational choice theory.
Yeah.
You're telling the listener that if they know exactly what the punishment is, they'll weigh the cost and maybe decide that bank robbery just isn't worth it.
It's treating people like they have an actual brain, not just a nervous system that feels pain.
Which was a huge aha moment.
It really was. If humans are rational, you don't need to torture them. You just confine them so they can reflect. That's literally where the word penitentiary comes from, penitence.
It was the very first time we thought a person could actually change. But for a long time, every country just sort of did its own thing.
Yeah, it wasn't until the 1930s that the League of Nations and the IPPC started saying, wait, how we treat prisoners is actually an international concern.
And then World War II happens. And the world realizes that if a state can do whatever it wants to people behind closed doors, things get dark really fast.
That's why we see this massive explosion of rules. From the Universal Declaration of Human Rights in 1945 to the Rome Statute in 1998,
which created individual criminal responsibility, meaning you couldn't just say, I was following my country's laws if those laws were inhumane.
Exactly. And one of the biggest protections you have now is the principle of legality. Nullum crimens sine lege.
The idea that the government can't just decide today that something you did yesterday is suddenly a crime.
It keeps the rules of the game fair. But look at the conditions inside. The 2015 Nelson Mandela Rules set a very hard line on solitary confinement. 15 days.
I was actually looking at that. Why 15 days specifically? It feels arbitrary until you look at the research.
Because medical studies show that around day 15, the human brain starts to physically and psychologically break.
Right. So if you go past that, you're not disciplining someone anymore. You're causing permanent neurological damage.
Which is why international law now calls anything over 15 days a form of torture. It's about recognizing human limits. And the 1966 ICCPR actually mandates that the primary goal of prison must be social rehabilitation.
It's not about an eye for an eye anymore. It's about how do we get this person back into society? But the rules aren't one size fits all.
No, not at all. You have the Beijing rules for kids, which say locking up a juvenile has to be the absolute last resort.
And for the shortest possible time. But I think the Bangkok rules for women are the real game changer here. Because for a long time, equal treatment in prison just meant treating women like men.
And that was a complete disaster. The Bangkok rules recognize that about 80% of incarcerated women are primary caregivers.
So if you treat a mother exactly like a male inmate without considering healthcare or her children, you aren't just punishing her.
You're effectively punishing a child who isn't even in the system. These rules mandate gender-specific healthcare and support for mothers. It's acknowledging that equal doesn't always mean the same.
We even see these limits on the death penalty. It's not universally banned, but international law draws hard lines. No executions for anyone under 18, pregnant women, or people with mental disabilities.
We've fundamentally redesigned justice. We've gone from a system that used a person's body as a canvas for state power to a framework that prioritizes due process, the presumption of innocence, and the hope of reformation.
It's a massive evolution. But it leaves you with a pretty heavy question to chew on as we wrap up.
What's that?
Well, if the primary goal is now reformation rather than physical pain, how does the shift to psychological confinement change what justice actually feels like? Is taking away someone's time and mental space truly more humane than the physical punishments of the past? Or have we just found a quieter way to be just as tough?
That is a really profound way to look at it.
Something for you all to think about. Thanks for joining us on this exploration.
You know, you can tell a lot about a society by how it chooses to punish people. And that story, wow, it has changed dramatically over the years. We've gone from these brutal public spectacles to a really complex system that's all grounded in the idea of human rights. So today, that's what we're diving into, that exact evolution.
So yeah, that's the big question, right? How in the world did we get from there to here? This whole journey really shows a massive shift in how we think about what justice is even for. To get it, we've got to start by looking back at a time when justice looked, well, very, very different.
I mean, at its heart, the entire philosophy just completely flipped on its head. The old way was pretty simple, retribution, an eye for an eye. The method was direct. It was all about inflicting physical pain on the body. The new way, though, has a totally different goal, rehabilitation. And the main method? Incarceration. It's this huge change from punishing the body to trying to reform the mind.
Okay, so to really grasp how big this change was, we have to look at the baseline. And for most of human history, let me tell you, justice was a public event, and a pretty terrifying one at that. Before we got to the modern era, punishment was basically theater. It was designed to be seen by everyone. It was physical, it was severe, and it was personal. We're talking things like torture, public humiliation in the stocks for everyone to see, even being branded with a hot iron. And the point wasn't just to punish the one person. Oh no. It was a brutal way to send a message meant to scare everyone else straight.
And then this idea comes along, an idea that sounds so simple to us now, but back then it was absolutely revolutionary. Thinkers during the Enlightenment, like Cesare Beccaria, started to challenge the whole idea of random, cruel punishment. They were all about reason and dignity, which flew in the face of a system built on causing pain. They argued justice should be rational, that it should be measured, not just an emotional spectacle. And that little spark, that was the beginning of the end for the old way.
Now, an idea like that doesn't change the world overnight. It took centuries to really take root. But what truly forced the issue, what created a truly global conscience, was the unbelievable horror of the 20th century. That's when the whole world started saying, okay, we need to talk about how we treat prisoners. For the very first time, it became an international concern. And you can actually see it happen right here on this timeline. It kind of starts small, back in the 30s with the League of Nations. But then, after the horrors of World War II, everything just kicks into high gear. In 1948, the Universal Declaration of Human Rights flat out forbids torture. That paves the way for the first global prison standards in 1955, and then much more recently in 2015, they're updated and renamed the Nelson Mandela Rules, a powerful tribute to a man who spent 27 years in prison to keep refining what it means to treat people humanely.
And another huge thing came out of World War II, especially from the Nuremberg trials. It was a brand new principle, individual criminal responsibility. For the first time, it wasn't just countries that could be guilty. People could be held responsible for crimes against humanity. It basically meant that some acts are so awful they're everyone's problem, and you can't just hide behind your government or your flag anymore.
Okay, so that's the history. That's how we got here. But what's actually in this modern rulebook? What does justice look like now under these international standards?
All right, first up is a huge one, the principle of legality. It sounds fancy, but it's pretty simple. You can't be punished for doing something if it wasn't actually a crime when you did it. This stops governments from just making up laws after the fact to target people. The law has to be clear, and it has to exist first. It's just a fundamental rule of fairness, really.
And then there's this, a line in the sand. The ban on torture is absolute. I mean, there are zero exceptions. Doesn't matter if there's a war, a national emergency, nothing. This is completely non-negotiable.
And to show you how specific this gets, look at this number. 15 days. Under the Mandela Rules, putting someone in solitary confinement for more than 15 days in a row is defined as prolonged and is considered a form of cruel and inhuman punishment. They put a hard limit on it because they know the psychological damage it can cause. And this all ties back to that big shift in thinking we mentioned at the beginning. The goal isn't just to lock someone up and throw away the key. The whole point, according to these modern standards, has to be about reformation, about rehabilitation, about actually preparing someone to be a part of society again.
So what does that look like day to day? Well, the Mandela Rules break it down into some core ideas. First, you have to treat every prisoner with dignity. Second, you have to separate different groups of prisoners, like people awaiting trial from those already convicted. And third, you've got to cover the absolute basics: food, hygiene, medical care.
But the rules also get that you can't just have a one-size-fits-all approach. Some people are just way more vulnerable in that kind of environment, so the system has these special protections built right in for them. When it comes to kids, for example, the number one rule is try to avoid prison at all costs. It's really seen as the absolute last resort. And even if it has to happen, it has to be for the shortest possible time. The whole focus shifts from punishment to protection and rehabilitation. It's a similar idea for women. There's a whole separate set of guidelines called the Bangkok Rules designed just for them. It recognizes their unique circumstances, addressing things like gender-specific healthcare and making plans for women who are in prison with their children.
Okay, so what about the big one, the death penalty? Now, it's not totally banned everywhere, but international law puts some really strict guardrails around it. It's meant to be used only for the most serious crimes, which usually means intentional killing. And there are hard lines. You absolutely cannot use it on someone who was under 18 when they committed the crime or on pregnant women. Period.
So we've gone through the history, the rules, all the details. Which brings us to the big "so what" question. Why should we even care about all these standards?
Because here's the thing, and if you take away one thing from this, let it be this. These rules aren't really for the offenders. They're for us. They define the kind of society we want to be. They are the line we, as a humane society, agree we will not cross, no matter what someone has done. At the end of the day, how we treat people who have broken our rules says everything about who we are.
And you know, this story isn't finished. Not by a long shot. Justice is always changing, always evolving. Which kind of leaves us with one last thing to think about. As our world keeps changing, our technology, our values, what's the next evolution of justice going to look like?
I want you to try and do something for me right now. Just close your eyes for a second. We are going to go on a little trip.
A historical trip.
Right, a historical trip. I want you to imagine the town square, but, not the one you know today, with the artisanal coffee shop and the farmer's market selling overpriced kale.
Oh, yeah. Definitely not that one.
No. We're going back 500, maybe 600 years.
To a time when the town square was really the center of the universe.
Exactly. And it is packed. It's shoulder to shoulder. It is loud. It's chaotic. It smells, well, honestly, it probably smells absolutely horrific.
Unwashed bodies, livestock, mud, all of it.
Yeah, all of it. But nobody is there to shop. They aren't there to gossip with their neighbors. They're all facing the exact same direction because they're watching something.
They're there for the show, the spectacle.
And the star of this show isn't a musician or, a politician giving a speech. It is a criminal. Maybe they are locked in the stocks, getting pelted with rotten fruit and rocks. Maybe they're being branded with a hot iron. You've got the smell of burning flesh just mixing right in with the street air.
It's a very intense sensory experience.
Extremely. Or maybe, and this would be if it is a really special occasion, it is a public execution. It is visceral, it is bloody, and it is happening right in your face.
Historians actually call it the theater of punishment. And that term isn't an accident. It was heavily designed to be a performance.
A literal performance.
Yes, a play where the state was the director and the criminal was just a prop on the stage.
Okay, so now I want you to snap back to today. Open your eyes. Think about what happens if someone breaks the law right now.
They vanish.
They completely vanish. They are taken to a concrete building, usually miles and miles away from the city center, and it's tucked behind high walls and razor wire.
Out of sight, out of mind.
Exactly.
Yeah.
It is quiet. It is highly regulated. You've got forms to fill out in triplicate. There are literal calorie counts for the meals they get served. It feels very bureaucratic. Yes. It's so administrative.
And that is the massive shift we're looking at. It is the shift from punishing the physical body to managing the individual person, moving from the visceral, bloody town square to the administrative spreadsheet.
That shift going from the branding iron to the rule book, it is one of the biggest changes in human history, really. But here is the question that I stumbled upon while we were prepping the research for this. And it is the question that really anchors this entire deep dive today.
The big question.
Right. Who actually decides how a government is allowed to punish you?
That is the core of it all.
Because for a long, long time, the answer was basically just the king decides and you just have to deal with it.
And honestly, that answer worked for centuries. If you were a subject, your physical body belonged to the crown. The king literally owned the justice system.
Today we have a very different answer to that question.
We do. We have this massive, incredibly complex global web of standards. Standards that dictate everything from exactly how many square meters a prison cell must be, to the temperature of the food they serve, to how many days someone can spend in isolation before it crosses the line and becomes a crime against humanity.
Welcome to today's deep dive. I'm your host, and joined by our resident expert, we are unpacking the source material titled The Evolution and Elements of International Penal Standards.
Thrilled to be here for this one. It's a heavy topic, but so crucial.
It is. And look, I know that title sounds a bit dry. It sounds like we're about to just sit here and read a legal textbook to you.
It really does.
But trust me, this is not just about prisons. This isn't just a deep dive into administrative law.
Not at all. It is about the absolute limits of power.
It is about the line between justice and total tyranny. Our mission today is to trace how humanity moved from physical retribution, literally destroying the human body, to a system that is fundamentally grounded in human rights, dignity, and this highly controversial idea of rehabilitation.
It is essentially the story of how we as a species decided that even the quote-unquote worst among us, the murderers, the terrorists, the violent offenders, are still fundamentally one of us.
And that is a very hard decision for society to make.
A painfully hard decision.
So we have a stack of sources here, mostly drawing from that main text on the evolution of penal standards, plus some supporting historical documents. We're going to distill all the key takeaways for you. And to keep us on track, we have broken this down into a 4-part roadmap.
A very necessary roadmap.
Right. First, we are visiting that horrific history we just imagined, the body era. Second, the big philosophical pivot, which is the actual invention of the prison.
Which, as people often forget, is a surprisingly recent piece of technology. The prison, at least as we know it today, is younger than the steam engine.
That fact alone just blows my mind every time I think about it.
It's wild.
Okay, third on the roadmap, the post-World War II revolution, the Nuremberg trials, and the United Nations. And finally, we're going to open up the modern rule book itself, the Mandela Rules, and look at the absolute prohibitions that exist in the world today.
It is a journey from pure chaos to strict codification.
So let's just dive right in. Phase 1, the pre-modern era, or, as the history books sometimes like to gloss over it, the good old days.
Yeah, there's absolutely nothing good about it if you were on the wrong side of the law, or even, frankly, if you were just a spectator in that town square.
The source material makes a really specific distinction right off the bat here. It says this early era was focused entirely on the physical body.
Exclusively the body.
Why the body? I mean, why not just lock people up? Dungeons definitely existed back then, right? We see them in all the movies.
Well, they existed, sure, but usually they were only there to hold you until your actual punishment happened. They were holding pens. You really have to look at the economics and the technology of the time.
Yeah.
Think about building a secure facility to house, feed, clothe, and guard, let's say, 500 men for 10 years.
That sounds expensive.
It is incredibly expensive. It requires deep infrastructure. It requires a massive bureaucracy, steady taxation to pay for it, and a standing police force to run it. A medieval king simply does not have that kind of budget.
Right. He has got a giant stone castle and an army for wars, but he does not have a Department of Corrections.
Exactly. He does not have the administrative capacity. But a branding iron, a leather whip, a hemp rope.
Very cheap.
Those are cheap. And they are reusable. So partly the intense focus on the body was just a resource issue. It was highly efficient.
That is so grim, but it makes perfect economic sense.
But it was also deeply philosophical. The physical body was the canvas. You brought up the town square earlier. The punishment absolutely had to be public because the goal of the state was twofold: retribution and deterrence.
Okay, let's break those two concepts down for the listener, because they are foundational. Retribution is basically the classic eye for an eye, right?
Exactly. Lex talionis, the ancient law of retaliation.
Lex talionis.
Yes. It is a very deep, almost primal human instinct, isn't it? You hurt the community, so the community has to hurt you back to balance the cosmic scales.
It satisfies a need for symmetry.
Right. It's symmetrical justice.
Right.
If you steal a loaf of bread, you lose the hand that stole the bread. If you speak treason against the crown, you lose the tongue that spoke the treason.
It is almost poetic in a really twisted, grim way.
Yeah.
But the deterrence part, that is where the whole spectacle comes in. That is why you need the massive audience in the town square.
Precisely. The core idea was general deterrence. If you, just an average baker or a blacksmith, are standing in the crowd and you see a thief literally get his hand chopped off, or you see a heretic burning at the stake, you are going to be absolutely terrified to step out of line.
You're going to go back to your bakery and be a model citizen.
Exactly. The state is using the criminal's physical suffering as a billboard. They are broadcasting a massive message of power through the criminal's pain.
So it is essentially terror as a state management style.
Effectively, yes. Michel Foucault, the French philosopher, he wrote extensively about this exact dynamic.
Oh, in Discipline and Punish.
Yes, that's the one. He argued that in this pre-modern era, the crime wasn't just breaking a rule. It was seen as a literal physical attack on the king himself.
Even if you just stole from a neighbor.
Even then, because the king's peace was broken, so the punishment was the king's direct personal vengeance. It had to be completely overwhelming to show the public that the king's power was absolute and untouchable.
The sources list the methods used, and man, they are rough. Death is on there, obviously, but also banishment.
Which a lot of people think sounds mild compared to execution.
Right, like, oh, you just have to leave town.
But it was essentially a delayed death sentence in a lot of places. You get kicked out of the safety of the village, you have no social support, no protection from bandits, you likely just starve or freeze in the woods.
Wow. And then the sources also mention the humiliation punishments, the stocks, the pillory.
Those were entirely about psychological warfare. The community participation was the key ingredient there.
Because it wasn't just the executioner punishing you.
Right. It was your actual neighbors throwing the rotten vegetables or the stones. It reinforced the social bond of the quote-unquote good group by violently expelling and shaming the quote-unquote bad other.
And notice what is completely missing from that entire list of methods. Correction.
Right. There's absolutely no attempt to fix the guy.
None at all. The concept of rehabilitation was virtually non-existent in this era.
Think about the underlying logic. If you brand a convicted thief on his forehead with the letter T, which was a very real punishment they did, you aren't trying to reintegrate him into the local workforce.
You aren't hoping he goes to trade school.
No, you aren't hoping he learns a new skill. You are permanently, physically marking him as an outcast. You are permanently altering his physical form to reflect his crime.
It is a totally one-way street. There is no coming back to polite society from a letter burned into your face.
Zero coming back.
This brings me to the legal side of things. Who actually set these rules back then? Was there some sort of medieval Geneva Convention that said, well, you can chop off a hand, but you can't take a foot?
Absolutely not. And this is honestly the hardest part for modern democratic minds to really grasp. We are so incredibly used to the idea of rights.
Right, human rights. The idea that you have rights simply because you are a breathing human being.
Yes, but in the era of the sovereign, that entire concept just did not exist.
The king was the law.
Literally. The Latin phrase was rex lex, the king is the law.
Yeah.
The sovereign had total, absolute authority over the subject. If the king suddenly decided he wanted to boil you in oil for a minor offense, there was no Supreme Court you could appeal to.
There was no Amnesty International.
There was no United Nations to write a sternly worded letter of condemnation. You belong to the sovereign in the exact same way the trees and the land belong to the sovereign.
It is total terrifying vulnerability. You're just a disposable pawn on the board.
Exactly. The source text explicitly mentions that sovereign states had absolute authority. The very concept that a quote-unquote human right could stand up as a legal shield between a king and his subject was basically political science fiction.
It would be like, I don't know, it would be like your toaster claiming it had legal rights against you when you plug it in.
That is a great analogy. It just simply did not compute in their worldview.
So we have this medieval system of arbitrary, spectacular cruelty. It's messy, it's incredibly bloody, and frankly, as you pointed out, it is highly inefficient.
Very inefficient.
Because if you just kill or permanently maim everyone who messes up, you are rapidly losing your workforce. You are losing taxpayers.
Exactly.
But then we hit the 18th and 19th centuries, and we enter phase 2 of our roadmap, the Enlightenment.
The great intellectual rebellion against all of that arbitrary cruelty.
People start looking at these massive public tortures in the town square and thinking, wait a minute here, this isn't civilized. And actually, it might not even be working to stop crime.
Right, the crime rates weren't exactly zero.
The source material introduces two really heavy hitters here who changed everything. Cesar Beccaria and Jeremy Bentham. Can you give us the elevator pitch on these two guys?
Happily. These guys were the ultimate disruptors of the penal system. Beccaria, he is really considered the grandfather of modern criminal law. He was this Italian aristocrat, and in 1764, he writes this highly explosive little book called On Crimes and Punishments.
It caused a huge stir.
Oh, massive. It was a bestseller.
Yeah.
He argued something that was completely radical for 1764. He said that punishment should not be about God's wrath or the king's personal anger. It should be mathematical.
Mathematical. I mean, that sounds a little cold.
It sounds cold to us now, but in the context of the 1700s, it was incredibly humane compared to the alternative of just being drawn and quartered.
Fair point.
He introduced the concept of proportionality. The punishment should fit the crime, but crucially, it should not exceed the crime. And he, along with Jeremy Bentham over in England, pushed what we now call rational choice theory.
Okay, let's unpack rational choice theory, because that sounds way more like modern economics than it does criminology.
Well, it really is economics. It's basically behavioral economics way before anyone invented that term. They argued that criminals aren't possessed by literal demons, and they aren't necessarily born inherently evil.
Okay, then what are they?
They are rational actors. They are making a calculation. They weigh the benefit of the crime, say the immediate pleasure of eating that stolen loaf of bread or the financial profit from stealing a bag of gold, and they weigh that against the potential cost of the punishment.
So the criminal is running a rapid cost-benefit analysis in their head.
Exactly. So Beccaria looks at this and says, well, you don't need to physically draw and quarter a man for stealing bread. That is massive overkill. You just need a punishment that is slightly more painful than the pleasure they got from the bread.
You just need to slightly tip the scales the other way.
Precisely. Just enough to make the rational choice be, you know what, I won't steal today. Beccaria forcefully argued that anything beyond that minimum necessary amount of punishment is tyranny. It is just state-sanctioned cruelty for cruelty's sake.
He basically told the kings of Europe, the state only has the moral right to use the absolute minimum amount of force necessary to maintain public order.
That is a huge seismic shift in political thought.
That is the government being told to limit itself.
It is. And this specific philosophical shift leads directly to the invention of the penitentiary. And I really love that you used the word invention earlier.
Yeah, we did take prisons for granted. Like
Yeah.
they have just always been there right along with the mountains and the oceans.
Exactly. But the source text frames the prison as a specific piece of technology that was deliberately developed to replace bodily torture.
It was a massive pivot for human society. We moved from physical pain as the currency of punishment to time as the currency.
Time as currency. That is the crucial foundational phrase for modern justice. Instead of the state taking your hand, we take your freedom. We take your calendar years.
We are fining you, but we are paying the fine with your lifespan.
That is exactly what a prison sentence is. And the actual architectural change of the era heavily reflects that philosophical change. We go from the dungeon, which again is just a dark holding pit, to the individual cell.
The quote-unquote correctional facility.
Right. And the Quakers over in America, specifically in Pennsylvania, were huge influences here.
Really, the Quakers.
Yes, because they deeply believed that crime was fundamentally a moral failing, a sin. And how do you cure a sin in their religious framework?
I'm guessing not by whipping the physical body in the town square.
No, by fixing the inner soul. So they theorized that if you physically removed a person from the corrupting loud noise of the city and you put them in a completely silent, highly structured environment, a penitentiary, they would naturally do penance.
Wow. Penitentiary, penance. I have literally never connected those two words before.
Yeah.
Right now.
It is right there in the name. The original idea was that they would sit in silence, they would reflect on their bad deeds, they would read the Bible, and they would eventually be cured of their criminality.
So the primary goal completely shifts from physically destroying the body to psychologically fixing the mind.
In theory, yes, it was the birth of the modern penal system as we recognize it. But, and this is a very big dita, but for our timeline, it was still entirely a domestic affair.
What do you mean by domestic?
I mean, each individual country was just figuring this out on its own. There were no global rules. If France wanted to run a brutal, terrible prison system, well, that was France's business.
Nobody else could intervene.
Right. If Russia wanted to run massive freezing gulags, that was Russia's internal sovereign business. The rest of the world hadn't stepped in yet to say otherwise.
And that perfectly brings us to Section 3 in our roadmap. The moment the rest of the world finally decides to peek over the neighbor's fence.
The globalization of justice.
It starts pretty quietly, according to the sources. The League of Nations in the 1930s.
Yes, the precursor to the UN.
The source text says the League, quote, took note of rules drafted by the IPPC, the International Penal and Penitentiary Commission. Now, as a reader, that sounds incredibly weak. We noted your rules.
Well, it was weak. The League of Nations, frankly, didn't have any real teeth. It was mostly a high-minded debating club for diplomats.
Right.
But symbolically, it was huge, because it was the very first time an international political body formally acknowledged that how a single country treats its own prisoners is an international concern.
It chipped away at that ironclad idea of absolute domestic sovereignty we talked about in Phase 1.
Exactly. It was the world clearing its throat and saying, hey, we see what you were doing inside your borders, and we actually have opinions about it.
But the real catalyst for change wasn't just a bureaucratic meeting in Geneva. It was the apocalypse. World War II.
You really cannot overstate the impact of World War II on international law. You had these civilized, highly industrialized, supposedly enlightened nations using their own legal and penal systems to commit mass genocide.
They used the actual bureaucracy of the prison to industrialize death.
Exactly. The concentration camps. The Nazis didn't just run out and kill people in a wild frenzy. They built massive camps. They had strict regulations. They had intake forms. They took the technology of the prison and they completely perverted it into a literal machine of extermination.
And after 1945, the rest of the world looked at the ashes of those camps and realized that domestic sovereignty could never again be an excuse for that kind of horror.
That excuse died at Auschwitz. The global community collectively realized that there are some crimes that are so deeply heinous that they are crimes against humanity itself, not just violations of local state laws.
And that realization leads directly to the Universal Declaration of Human Rights, the UDHR, in 1948.
Which is a monumental document. It explicitly bans torture or cruel, inhuman, or degrading treatment. That is the cornerstone of everything we are talking about today. Article 5. It is a very short sentence, but it quite literally changed the world.
But, as we know, putting words on a piece of paper is one thing. Actually enforcing them against powerful governments is another.
That is the eternal struggle of international law.
That is where the Nuremberg and Tokyo tribunals come in. And I have always found this part of history fascinating because it flipped the entire legal world upside down. Before Nuremberg, if a soldier committed a horrific war crime, what was his standard legal defense?
The standard defense was, I was just following orders. Or the higher level legal defense was acts of state.
Acts of state.
The argument was that the abstract state is the entity acting, not the individual man. The soldier is just a finger on the giant hand of the state. You can politically sanction the country of Germany, but you cannot legally hang Hans the soldier.
The sovereign shield.
Nuremberg pierced that shield. It didn't just pierce it, it smashed it to pieces. It established the doctrine of individual criminal responsibility.
Manny.
It said to the soldiers and the generals, no, you did this. You made a personal choice to follow that order, and you as an individual will be punished.
That is such a massive shift in how we view accountability. Suddenly, the king's executioner can be dragged into court and put on trial by the rest of the world. It means absolutely nobody is safe hiding behind a government title.
It changed everything. It meant that international law could finally reach inside a country's borders and grab an individual person. And from the rubble of that war, the international community started furiously building the modern code.
Let's run through the timeline of that code really quickly, just to set the stage for the modern rules, because it seems like right after the war, there was this desperate rush to write absolutely everything down before it happened again.
There really was. It starts in 1955. The UN formally adopts the Standard Minimum Rules, the SMR.
The SMR.
Right. This was essentially the very first global user manual for how to run a prison.
And then in 1966, we get the ICCPR. The International Covenant on Civil and Political Rights.
Now, there is a very crucial legal distinction to make here. The 1955 SMR was a guideline. It was a strong recommendation from the UN.
But you couldn't really force anyone to follow it.
Exactly. But the 1966 ICCPR is a treaty. It is a legally binding international document. If a country signs it and ratifies it, they are promising, under the threat of international law, to treat all their prisoners with basic humanity.
Okay, moving down the timeline. Then we hit 1998, the Rome Statute, which officially created the International Criminal Court.
The ICC. This was the creation of a permanent enforcement mechanism for those worst of the worst crimes we talked about. It is the global court that can actually put the genocidal dictator on trial.
And finally, jumping to very recently, 2015, the Mandela Rules.
Which was the massive, much-needed update to those original 1955 standard rules. They renamed them after Nelson Mandela to specifically honor his 27 years spent in prison.
A very fitting tribute.
Absolutely. And these new rules reflect our modern 21st century understanding of psychology, of medical science, and of complex human rights. It is the absolute gold standard today.
So if we look back, we have gone from a world with literally no rules, just the whim of the king, to a highly detailed global user manual.
A very long journey.
Let's transition to section 4 of our roadmap and actually crack open that manual. What are the absolute hard lines in the sand today?
The whole system is built on a few unshakable pillars. The first one is a fancy Latin phrase that international lawyers absolutely love to use. Nullum crimen sine lege.
Nullum crimen sine lege, which translates to no crime without law.
Sounds pretty simple, right? Sounds like basic common sense.
It does.
But think about the alternative if we didn't have that rule.
The alternative is the government just making up rules as they go along whenever they want to arrest somebody.
Precisely. The core concept of the rule of law means that the rules of the game must be written down and published before you are forced to play the game.
Right.
This specific principle dictates that you cannot be punished for an act that was not legally defined as a crime at the exact time you committed it. It aggressively protects all of us from retroactivity.
Okay, so let's play a hypothetical to make sure we've got this. If the government passes a brand new law today, completely banning, I don't know, the use of cryptocurrency.
Okay, crypto is banned today.
They cannot send the police to arrest me for the Bitcoin I bought 3 years ago.
Correct. They absolutely cannot. Because when you bought that Bitcoin 3 years ago, it was perfectly legal. You couldn't possibly have known it would become a crime later.
That makes sense.
Because if laws can travel backward in time like that, nobody is ever safe. You are always potentially a criminal just waiting for the law to change and catch you out.
So the international standard requires that laws must be clear, they must be precise, and they must be entirely forward-looking.
You have to be given the opportunity to know the law in order to obey the law. That is fundamental fairness.
Okay, pillar 2, the absolute prohibition of torture.
And I really want to stress the word absolute here.
The source material really hammers this point home. Are there genuinely any exceptions at all? What about the classic ticking time bomb scenario?
Everyone always asks about the ticking time bomb.
Right. You know, the action movie scene where the captured terrorist knows exactly where the nuke is hidden in the city and the clock is ticking down. Can the police bend the rules then?
No exceptions. None. Zero. International law is completely unwavering on this specific point. Torture and cruel, inhuman, or degrading treatment is banned in all circumstances everywhere.
No matter what.
Active war, severe political instability, massive terror threats, none of it legally justifies the use of torture, ever.
Why is it so incredibly strict? Because usually the legal system loves to carve out an exception for extreme circumstances.
Because history has shown us that once you open that particular door, even a tiny crack, the door gets violently kicked wide open by bad actors.
Give an inch, they take a mile.
Exactly. If the UN says, well, torture is okay if it immediately saves civilian lives, suddenly every single authoritarian dictator on earth argues that torturing his peaceful political opponents is saving the nation's lives.
I see.
The absolute prohibition acts as an unbreakable firewall against state abuse.
But we do need to clearly define what torture actually is. Because I think when most listeners hear that word, they imagine the medieval rack or modern waterboarding or electric shocks.
The extreme stuff.
Right. But the definition provided in the source text is significantly broader than just that.
Much, much broader. The definition legally includes corporal punishment.
Meaning physical strikes.
Yes. So whipping, flogging, caning things that are actually still legally practiced in some parts of the world today, those are clear, direct violations of these international standards.
So the state is just not allowed to physically strike a captive prisoner as a form of punishment.
Never. And then there is the issue of solitary confinement. This is an area where modern medical science has really heavily influenced international law. The Mandela Rules are extremely specific about this.
They really are. They explicitly define prolonged solitary confinement as anything in excess of 15 consecutive days.
Yes, 15 days is the magic number.
Why 15, though? Why not 14 days or a clean 30 days? That seems like a remarkably specific number to put in a global treaty.
It is remarkably specific, and it is entirely based on clinical medical data. The psychological evidence strongly suggests that right after that 2-week mark, the damage happening to the human brain becomes qualitative.
Qualitative. What does that mean in this context?
It means it shifts from just being high stress, which the brain can recover from, to actual physical injury to the neural pathways.
Wow.
You start seeing severe psychosis, vivid hallucinations, crippling anxiety, and in many cases, completely irreversible cognitive decline.
So the brain essentially starts eating itself because of the total lack of external stimulation.
Exactly. Human beings are deeply social animals. Our brains literally require social contact and environmental varied inputs to maintain a grip on reality.
We need to see other faces.
Right. So under international law, locking a human being in a concrete box for 22 hours a day for more than 15 consecutive days is not just considered a harsh prison rule, it legally constitutes torture or severe ill treatment.
It is incredibly fascinating that we have to put a hard number on it like that. We have to draw a literal line in the sand where strict custody suddenly becomes a human rights violation.
But that is exactly the vital function of the law. Its job is to convert abstract philosophical principles, like humanity, into concrete, enforceable metrics, like 15 days.
Because if it's vague, it's useless.
Right. If you just tell a prison warden, hey, don't be cruel, every single warden on Earth will have a completely different personal definition of what cruel means.
Sure.
But if you write down 15 days, you have an objective standard. You can send an inspector to physically check the logbook. You can count the days.
Let's move smoothly into Section 5 of our outline. Life inside the prison. We have talked a lot about what the state absolutely cannot do, like torture.
What's the negative obligations?
Right. But what about what they must do? Because it seems to me, once the state forcibly takes away your freedom and locks you in a cell, they basically become entirely responsible for your minute-to-minute survival, right?
That is referred to legally as the duty of care. And the core philosophy driving this entire section of the rules is dignity. It's principle 4 of the Mandela Rules.
Dignity.
Yes. The underlying belief is that even if a man is a convicted multiple murderer, the state absolutely cannot strip him of his inherent dignity as a human being.
Because he is still fundamentally a person.
Exactly. You punish the crime by taking the time, but you cannot destroy the person.
And practically speaking, the sources show this leads heavily to what they call the logic of separation.
Oh, yes. The modern rules are entirely obsessed with strict categorization.
Why?
Well, you cannot just throw 500 random people into one big pit. That is the chaotic, pre-modern way. It is incredibly dangerous for the inmates, and it's chaotic to manage. The modern, enlightened way requires careful separation.
Okay, let's run through the separation rules. First, men must be separated from women.
Basic safety and vulnerability protections.
Second, children must be separated from adults.
Also seems very obvious to us today to protect the youth from predatory adults.
It does. But there is another separation rule that the sources highlight, and honestly, this one gets ignored a lot in underfunded systems all over the world.
I know exactly which one you mean.
Pre-trial detainees must be separated from convicted criminals.
This is absolutely vital to the integrity of the justice system. A pre-trial detainee is, by legal definition, completely innocent.
The presumption of innocence. You haven't had your trial yet.
Exactly. They have not been convicted of a single thing. The only reason they are sitting in that cell is to ensure they actually show up for their court date next month.
Right.
Therefore, they absolutely should not be subjected to the exact same punitive conditions or forced to keep the same daily company as someone who has been legally proven guilty of a severe violent crime.
Let's play out the consequence of ignoring that rule. If you take an innocent 19-year-old kid who is just awaiting trial for, let's say, a minor shoplifting offense, and you lock him in a cell for 6 months with a hardened 50-year-old career criminal, what happens?
The prison immediately becomes a school for crime.
The school for crime.
That is what sociologists call it. The young kid goes into that cell for shoplifting, and he sits there for 6 months listening to the older guy, and he comes out with a PhD in armed burglary.
You are actively, intentionally creating significantly worse criminals with your own system.
The expert criminological term for this is the criminogenic effect of prison. The shocking reality is that a badly run prison can actually manufacture more crime than it prevents.
And on top of that practical failure, you are massively violating the fundamental human rights of an unconvicted person. You are punishing an innocent kid.
Which is illegal. Now, beyond separation, the rules also extensively cover basic human needs. Hygiene, natural light, fresh air ventilation.
This all sounds so basic, almost too basic to write into a treaty. But I know in a lot of overcrowded places globally, it is really not a given.
It isn't a given at all. And again, it all comes back to that word dignity. The rules are clear. The state does not have to provide a luxury 5-star hotel experience.
Obviously not.
But the state absolutely must provide physical conditions that actively sustain human life and baseline health.
So if a prison facility is so severely overcrowded that inmates are forced to sleep on the floor in rotating shifts,
That is a violation.
or if there is literally zero natural sunlight hitting the cells.
Also a major violation. You cannot legally punish someone by systematically destroying their physical health. The mandated punishment is solely the loss of liberty. It is not the loss of health or sanity.
Now, this naturally leads us to discuss the essential aim of all of this. Why are we even doing this as a society? Why do we build these massive prison systems?
This is where the conversation gets deeply philosophical. The ICCPR treaty we mentioned earlier, specifically Article 10, states very clearly that the essential aim of the penitentiary system is reformation and social rehabilitation.
Reformation and rehabilitation. But hold on a second. Let's be totally real here.
Okay.
If you take a microphone and go ask the average person walking down the street, or even if you ask half the politicians running for office why we send people to prison, they do not say rehabilitation.
No, they certainly do not.
They say punishment, they say justice, they want the criminal to pay.
And you have just identified the central pulsing tension of all modern justice systems. The immediate public instinct is very often purely a retribution. It is that medieval phase 1 thinking we talked about at the start. You severely hurt us, so we are going to severely hurt you.
Right.
But the binding international standard is firmly rooted in phase 2 and phase 3 thinking. It says to the criminal, look, we are strictly restricting your physical liberty, and that restriction is the entirety of your punishment.
The time is the punishment.
Yes, but the treaty says, while you are physically trapped in here with us, our primary administrative goal is to fix whatever is broken in you so that you can successfully come back to society.
Because, and this is the part people always forget when they get angry, almost everyone currently in prison is eventually coming back.
That is the ultimate practical reality. Something like 95% of all current prisoners will eventually finish their sentences and be released.
They are going to be standing in line behind you at the grocery store. They're going to be your neighbors again.
Exactly. So the real question for society is, do you want them coming out of that facility angry, psychologically broken, severely traumatized, and with a bunch of new criminal skills?
Definitely not.
Or do you want them coming out rehabilitated, educated, and ready to work?
So pushing for rehabilitation, it's really a highly pragmatic argument, just as much as it is a moral high ground.
It absolutely is. The international law legally mandates rehabilitation, even though the general public often intensely craves raw retribution. It is almost as if the legal system is actively trying to save society from its own worst, most vengeful instincts.
I love that framing. Let's move to look at the specific people involved in Section 6, due process and the vulnerable groups. Because as the sources point out, these global rules are not just a simple one-size-fits-all blanket.
Definitely not. True justice always requires deep nuance. You simply cannot treat a terrified 14-year-old girl in the system the exact same way you treat a 40-year-old organized crime boss.
Right. First up in this section, Principle 5, procedural guarantees. This is all the classic stuff we see every night on TV, courtroom dramas.
And the mechanics of the fair trial. You have the fundamental right to a public hearing. The state cannot run secret closed-door tribunals.
You have the right to a genuinely independent judge, not just a guy who is on the king's personal payroll.
Exactly. And the right to present a robust defense.
You have the right to know exactly what specific crime you are being charged with.
Yes, the police cannot just arrest you and hold you for general badness or vague suspicion. You need to see the paperwork.
And you have the right to legal counsel, to have a lawyer stand next to you.
All these procedures are deliberately designed to slightly level the incredibly steep playing field between the massive, infinite power of the state apparatus and the small, vulnerable individual.
Now, what about those individuals who need extra specific protection? Principle 6 focuses on the protection of vulnerable groups. Let's start with kids.
For juveniles, the international community relies on the Beijing Rules, as well as the overarching Convention on the Rights of the Child.
And the standard for locking up a kid is extremely high, right?
Very strict. The text says that the imprisonment of a child should only ever be used as a measure of absolute last resort.
The last resort.
And if you absolutely must lock them up, it must be for the shortest appropriate period of time.
Why is the international community so incredibly protective of keeping kids out of cells?
Because children are highly malleable. Their neurology, their brains are quite literally still developing. The trauma of a prison environment can permanently break a child, or it can harden them into a lifelong criminal much, much faster than it does to a fully formed adult.
Plus, just the heavy label of criminal, if applied that early, it just sticks so much harder to a kid.
It becomes their entire identity. It can completely ruin their whole life trajectory before it even starts.
And for women in the penal system, the sources highlight the Bangkok Rules.
Yes. The Bangkok Rules were adopted because the UN finally had to address the harsh historical reality that almost all prisons in the world were originally designed by men, exclusively for men.
The whole system was male-centric.
Entirely. The physical architecture, the daily security rules, the standard healthcare provisions, it was all built around a male baseline. The Bangkok Rules legally force prison systems to actively consider gender-specific needs.
What kind of needs specifically?
Basic female hygiene access, specialized reproductive health care, and perhaps most complex of all, the massive issue of women who have dependent children.
Right. If a single mother is sentenced to prison, what on earth happens to her child?
Exactly. The rules mandate very strict care protocols for those situations, ensuring that the child is protected and cared for so that the state system doesn't accidentally punish the innocent child for the legal sins of the mother.
Okay, finally, as we get near the end of the rules, we have to talk about the absolute ultimate punishment. Principle 7, the limitations on the death penalty.
A very heavy topic to finish the rules on.
Now, just to be totally clear for our listeners, based on the source text, international law does not currently universally ban the death penalty, right? Many, many countries still actively use it.
That is correct. It's not universally outlawed yet. But what the international community has successfully done is put the death penalty inside a very, very small, tightly controlled legal box.
They are trying to squeeze it out of existence over time.
That's the long-term goal for many UN states, yes.
So what are the actual walls of that tiny box? When is it allowed?
First and foremost, it is strictly restricted to only the, quote, most serious crimes.
Most serious crimes. What does that actually mean in practice?
Under strict international interpretation, that basically only means intentional, premeditated killing. Murder.
So you cannot legally execute someone for grand theft or massive corporate fraud or drug trafficking offenses.
Under strict international human rights standards, no, you cannot. Although, it is important to note, several sovereign countries do still frequently violate that specific standard regarding drug offenses.
And beyond the type of crime, there are certain categories of people that the rules say you can absolutely never execute under any circumstances.
Strictly prohibited categories.
Yes.
You cannot execute anyone who was under the age of 18 at the exact time they committed the offense.
Even if they are 50 years old when they finally go to trial.
Correct. The age at the time of the crime is what matters. Furthermore, you cannot execute pregnant women. And crucially, you cannot execute persons who have diagnosed mental or intellectual disabilities.
So even in the jurisdictions where the death penalty still legally exists, the global community has built these massive guardrails to say you absolutely cannot cross this moral line.
It is an international attempt to deeply limit the horrific irreversibility of the punishment.
Because it is so final.
Think about it. If you lock a man in a cell for 20 years, and then new DNA evidence comes to light proving he was completely innocent the whole time.
You can open the door and release him.
You can release him, you can pay him financial compensation, the state can formally apologize, it's a terrible tragedy, but you can try to make some amends.
But if you execute an innocent person,
there is no undo button on a lethal injection. The absolute finality of death inherently requires the highest possible standard of certainty and intense state restraint.
Wow. We have really covered a massive amount of historical and legal ground today.
We really have.
We have taken you all the way from the chaotic, visceral, blood-soaked town square where a king could just casually chop off your hand for stealing a bruised apple.
The intense body era.
To the highly philosophical mind era of the Enlightenment, where thinkers basically invented the modern prison as a quote-unquote humane mathematical alternative to all that torture.
And then watching the 20th century bring in the UN, the standard minimum rules, and the radical, beautiful concept that a human being has fundamental rights that absolutely no sovereign government can ever strip away from them.
It really is a long, slow trajectory pointing towards dignity.
It is exactly that, a trajectory towards dignity.
You know, it is really easy to look at the world today and just be deeply cynical about it all. We open our phones and we see terrible headlines about massive prison riots or tragic wrongful convictions or horrific abuse scandals, and we naturally get discouraged.
It can feel very bleak.
But when you actually step back and look at this entire timeline, from the red-hot branding irons of the Middle Ages to the precise medically informed Mandela rules of today, we have undeniably moved from a world where might makes right to a world where the law actively protects human dignity.
We have officially moved from the state having the unquestioned power to completely destroy its people to the state having the strict legal duty to protect its people, even and perhaps especially the very people it is actively punishing.
That is a profound evolution in human consciousness.
It really is.
And I think that is the ultimate takeaway here, isn't it? These dense legal rules we've discussed, the ICCPR, the UN mandates, the Mandela Rules, they aren't just boring bureaucratic red tape designed to annoy prison wardens.
Far from it.
They literally define the razor-thin boundary between a system of justice and a system of tyranny.
They absolutely do. They are the fragile line that separates a truly civilized society from a barbaric one. The famous Russian author Fyodor Dostoevsky actually said it best. He wrote, "The degree of civilization in a society can be judged by entering its prisons."
That is a powerful quote.
How you as a society choose to treat the people who have the absolute least amount of power, the people you have literally locked away behind concrete and steel, that says absolutely everything about who you really are.
I want to leave our listeners with one final kind of provocative thought to chew on after this deep dive is over.
Let's hear it.
We talked heavily about the quote-unquote essential aim of the modern prison being rehabilitation. That is what the official UN book says. That is what the binding treaty says.
But, as we also discussed, human history began with raw retribution. And that primal instinct for an eye is still buried very, very deep in our cultural DNA.
Exactly. So here is the real question for you to ponder. Have we truly completed that grand transition? Or are we, as a modern society, still just fundamentally stuck somewhere right between those two eras?
Trying to punish the body and heal the mind at the exact same time.
Right. Can a massive concrete building that is explicitly designed to lock people away in cages ever really be a place that sets them free?
That right there is the ultimate paradox of the modern prison system. It is desperately trying to be a hospital for the soul and a cage for the body, all at the exact same time. And whether that contradictory system can ever actually work, well, that is a difficult question every single society has to continuously answer for itself.
It is definitely something to think deeply about the next time you see a news headline about crime and punishment in your city.
Absolutely.
Thank you so much for taking this extensive deep dive with us today. It was a heavy one, but an important one.
It's been an absolute pleasure unpacking this with you.
Stay curious out there, and we will catch you on the next deep dive.
Welcome to the debate. Close your eyes for a second, if you would, and picture justice in the year 1650. You are likely imagining a public square, a cheering crowd, and a branding iron. It is visceral, it's loud, and it is bloody. Now picture justice today. You probably imagine a quiet courtroom, a sterile cell, and a code of conduct. We have moved from the pre-modern era, a time of public spectacle and physical pain, to a modern framework defined by soft law, rehabilitation, and the inherent dignity of the human person.
And that transition is exactly what we need to interrogate today. We are here to discuss the evolution and elements of international penal standards. But the core question isn't just about history, is it? It is whether this modern international justice system, with its Mandela Rules and its absolute prohibition of torture, has actually found the correct balance. Or have we swung the pendulum so far away from retribution that we are limiting the capacity for true justice?
It is a question that touches on the very definition of human dignity, specifically in the context of the state's power to punish. I will be representing the view that the evolution toward human rights represents a necessary moral maturation of global justice.
Right, and I will be taking the opposing view. While the end of arbitrary cruelty is obviously good, the modern framework's heavy reliance on soft law and prioritizing rehabilitation over retribution might actually obscure the necessary punitive function of justice for the most serious crimes.
Well, let's just dive right into the position statements. I want to start by planting my flag firmly on the side of this evolution. I believe the shift toward human rights, specifically the goal of rehabilitation and the protection of vulnerable groups, is a triumph of reason over cruelty. When you look at the source material, the trajectory is undeniable. We started in a place of arbitrary violence. The pre-modern era wasn't just violent, it was theatrical. Punishment was public, it was intensely physical. We're talking about mutilation, branding, the stocks. It was retribution in its rawest form, where the state had absolute authority to write its power directly onto the body of the subject.
Which was brutal, yes. But let's not pretend it was entirely pointless, or just sadism.
Well, it was arbitrary, which I would argue is the exact opposite of justice. The real shift began with the Enlightenment in the 18th and 19th centuries. You had philosophers like Cesare Beccaria and Jeremy Bentham, who looked at this theater of pain and realized it wasn't actually stopping crime. They introduced a concept that changed everything, which is proportionality. They argued that punishment shouldn't be about vengeance. It should be based on rational choice theory, meaning it is used only as necessary to prevent further harm. This led to the birth of the prison, the penitentiary, effectively replacing bodily torture with the loss of liberty. And today, in the United Nations era, from 1945 to the present, we have the Universal Declaration of Human Rights and the ICCPR, which legally binds states to treat prisoners with humanity.
My central thesis is that the principle of legality and the focus on correcting behavior rather than destroying the body creates a far more just society.
I think you are painting a very rosy picture of moral maturation, as you call it. Look, I certainly acknowledge the horrors of the past. Nobody is arguing we should bring back the rack or public branding. However, I worry that in our rush to embrace this enlightened framework, we are completely ignoring a fundamental human need. Even the source material for today's debate admits that retribution remains a factor. The transition you just described, from absolute sovereign authority to a mix of binding treaties in soft law like the Nelson Mandela Rules, leaves a significant gap.
A gap in what sense, though?
A gap in consequences. A gap in the moral weight of punishment. We have constructed a system heavily weighted toward Article 10 of the ICCPR, which mandates that the essential aim of the system must be reformation. But I have to ask, does that prioritize the offender over the victim? I am not convinced that soft law guidelines are robust enough to handle the grim reality of criminal justice, especially when we talk about the most serious crimes established by the Rome Statute. If the goal is purely rehabilitation, we risk obscuring the necessary punitive function that society absolutely demands. When the state refuses to punish adequately, the public loses faith in the state entirely.
I think that is a dangerous conflation of punishment with suffering. But let's dig into that first theme you brought up, which is the purpose of punishment itself. You mentioned retribution remains a factor, which is true, but the dominant movement has been away from the physical body for a very specific reason.
But why? That is the question I keep coming back to. Why is the body suddenly completely off limits?
Because the Enlightenment shift wasn't just architectural, it was deeply philosophical. Beccaria and Bentham argued against arbitrary cruelty not just because it was mean-spirited, but because it was grossly inefficient. They operated under a rational choice theory. The idea is that a criminal makes a calculation, right? They ask, is the benefit of this crime worth the cost? If the state inflicts pain beyond what is necessary to tip that calculation, it just becomes tyranny. The ICPR eventually codified this, stating the essential aim must be social rehabilitation. The goal is to return a functioning member to society, not a broken vessel. Because if you break the vessel, you just create a lifelong burden on the state.
See, that is the utilitarian argument perfectly encapsulated. It treats humans like calculators. But I do not buy that the only aim is rehabilitation, or even that it should be the primary one in all cases. The pre-modern goal of retribution, an eye for an eye, speaks to a fundamental human desire for balance. When a crime is committed, a moral debt is created. Retribution is the payment of that debt.
But we know exactly where an eye for an eye leads. It leads to blood feuds and cycles of violence that never actually end.
Or it leads to closure. The source material notes that in the pre-modern era, deterrence was achieved through fear. Now, we might find the methods like banishment or, death distasteful today, but the logic was actually sound. If the modern system, governed by things like the Nelson Mandela Rules, makes prison too comfortable, or focuses too heavily on correcting the offender, do we lose the deterrent factor? Again, we shouldn't return to the stocks, but we have to ask if the modern penitentiary is actually serving the purpose of preventing crime or just housing criminals until they are released to do it again.
Too comfortable? We are talking about the complete deprivation of liberty. That is the punishment. The loss of autonomy is incredibly severe. But let's look at where the rubber really meets the road regarding the state's power, and that is the absolute prohibition of torture and ill treatment. This is one of the foundational pillars of modern international penal standards, and I would argue it is the firewall that keeps civilization intact.
And yet, it is the one most frequently tested by actual reality?
Well, because it is inconvenient for power. But the standards are crystal clear. There are no exceptions. Not in war, not in a public emergency, not when you are fighting terrorism. This is where the protection of human dignity is most visible. The definition of ill treatment has expanded to include corporal punishment, like whipping or flogging, and specifically under the Mandela Rules, we have a strict ban on prolonged solitary confinement.
Let's look closely at that definition, though.
Sure.
It is defined as solitary confinement for anything over 15 days. This recognizes that psychological torture is just as damaging as physical torture. We know from clinical studies that after 15 days of isolation, the human mind simply begins to degrade. Hallucinations, psychosis, permanent cognitive damage. If we allow the state to do that to a human being, we are frankly no better than the pre-modern brutes with the branding irons. We are just hiding the scars on the inside. I mean, that is a compelling moral argument, but let's talk about the context of security. The no exceptions rule is morally attractive in a seminar room, but practically it is incredibly difficult. We are talking about sovereign states managing highly dangerous individuals. The Mandela Rules ban prolonged solitary confinement over 15 days. Okay, fine. But what if you have an inmate, a gang leader, or a terrorist who poses a continuous lethal threat to other prisoners and guards every single time he is let out of his cell?
Then you manage them through separation, through higher staffing ratios, specialized units. You do not just lock them in a concrete box and throw away the key.
But separation often looks exactly like solitary confinement to the person inside, doesn't it? Furthermore, you mentioned the ban on corporal punishment. Historically, states had absolute authority over how they punish subjects. Now, international standards say whipping is universally ill treatment. But is that definition actually universally accepted, or is this just a case of Western standards being applied to sovereign nations that might view corporal punishment as a valid traditional form of retribution? The tension here is between the universal ideal and the local reality.
Look, the local reality argument is almost always a cover for abuse. Saying it is our tradition to beat people is not a valid legal argument in the 21st century, and that is exactly why we needed the mechanics of international standards to shift, which brings us to our third theme, sovereignty versus universal rules. The turning point here wasn't just a treaty, it was the Nuremberg and Tokyo tribunals.
A significant moment, certainly. But let's be honest, it was also Victor's justice.
It was monumental because it pierced the veil of sovereignty. For the first time in history, individual criminal responsibility superseded state immunity. Individuals could be punished for genocide and war crimes completely regardless of what their domestic law permitted. If you were a guard at a camp, you couldn't say, "I was just following orders," or "it was legal in my country." This paved the way for the Rome Statute in 1998, creating the International Criminal Court. We created permanent international machinery, and crucial to this is the principle of legality, nullum crimen sine lege.
Right, no crime without law.
Exactly. No one can be punished for an act that wasn't a crime by law when it was committed. This protects the individual from the state. It prevents the arbitrary monarch's justice you seem to be slightly nostalgic for. It means the rules of the game are written down before you ever play.
I am not nostalgic for monarchs. I am simply realistic about enforcement. You talk about the Rome Statute and the ICC as if they magically solved the problem. But look at the components of these modern standards. They are a highly confusing mix of binding treaties and soft law.
But soft law guides the interpretation of hard law. It gives it necessary texture.
But it's still soft. That is the fundamental problem. The Nelson Mandela Rules are guidelines. The standard minimum rules adopted in 1955 were just that, minimum rules. Even back in the 1930s, the League of Nations only took note of the rules drafted by the IPPC. Taking note is very, very different from enforcing. While the Convention Against Torture is binding, the day-to-day management of prisoners relies heavily on these completely non-binding frameworks.
You are ignoring how international law actually works. It is evolutionary.
Is it? Because from where I sit, this creates a massive gap between the high-minded rhetoric of Geneva and the reality of a prison in a developing nation, or a developed one for that matter. If a country ignores the Mandela Rules and keeps someone in solitary for 30 days, who arrests the warden? Nobody. Soft law relies on shame, and some states are entirely shameless.
It relies on much more than shame. It relies on customary international law. Over time, soft law hardens into custom. Domestic courts start using the Mandela Rules to interpret their own constitutional rights. We see this explicitly in how we treat vulnerable groups, which is our fourth theme. The system has become incredibly sophisticated in recognizing nuance over the decades.
Nuance is good in theory, but does it actually work on the ground?
It absolutely does. Look at the Beijing rules for juveniles and the Bangkok rules for women. We aren't just lumping all criminals into one dark pit anymore. The standards require separation, men from women, children from adults, pre-trial detainees from convicted criminals. The Bangkok rules specifically address gender-specific health care and the complex care of children in prison,
which is incredibly expensive and logistically difficult for poor nations to implement.
Justice costs money. That is just the reality of a civilized world. But specifically, look at the strict prohibitions on the death penalty for minors, pregnant women, and those with intellectual disabilities. This is the very definition of a civilized society, protecting the most vulnerable among us, even when they are accused of terrible crimes. We have collectively decided that a child, no matter what they did, does not possess the full culpability of an adult.
I come at it from a completely different angle. You bring up the death penalty, and I think that actually proves my point about the persistence of retribution. You mentioned the prohibitions for minors and pregnant women. That is true, but the death penalty itself is not universally banned.
It is heavily restricted, though. The trend lines away from it are extremely clear.
Restricted, yes, to the most serious crimes, specifically intentional killing, under international law. But the fact that international law still permits the state to take a life, to physically eliminate an offender, reveals a massive contradiction in your entire narrative. You argue that the system is all about rehabilitation, about correcting behavior. But for the worst offenders, the international community still firmly holds on to the ultimate form of retribution. If rehabilitation was truly the absolute overriding goal, the death penalty would be abolished entirely across the board. Its continued existence proves that deep down, the system knows that some crimes require a price that rehabilitation simply cannot pay.
I would argue that represents a shrinking exception, not the rule. Most of the democratic world has turned decisively away from state-sponsored killing.
But the exception proves the rule. It proves that there is a hard limit to our mercy. When the crime is heinous enough, we revert right back to the pre-modern. We want the body.
Or we are slowly shedding that instinct generation by generation. The very fact that we are arguing about it on the global stage is the progress. But I see we are reaching the end of our time for today's discussion.
We are, and I think we have clearly highlighted that this isn't a settled science. To summarize my position, while the standard minimum rules and their evolution into the Mandela Rules are noble, the tension remains largely unresolved. We have moved the focus from the physical body to the mind, but we haven't figured out how to properly balance the basic human need for retribution with the modern goal of rehabilitation. I caution strongly against viewing soft law as a panacea for criminal behavior. When we prioritize the dignity of the offender above all else, we must be incredibly careful not to lose the deterrent power that actually keeps society safe.
That is a fair warning, though I would frame the conclusion quite differently. The shift from physical elimination to the preservation of inherent dignity is to me non-negotiable. It is the defining line between barbarism and civilization. The evolution from the League of Nations merely taking note to the UN era's binding covenants proves that the treatment of prisoners is a matter of global, not just domestic concern. We simply cannot go back to a world where the state has absolute authority to crush the individual. The limits on the power to punish are exactly what make us human.
Well, we can certainly agree that those limits define modern civilization, even if we fundamentally disagree on exactly where they should be placed regarding the most serious offenders.
Precisely. And there is so much more depth to this topic than we could possibly cover today.
Absolutely. We would like to thank you for listening to The Debate.
If this discussion sparked your interest, we highly encourage you to read the Nelson Mandela Rules for yourself. It is the best way to form your own opinion on the material.
Until next time.